You're walking down the street, just minding your own business. Maybe you're heading out to get a coffee or, maybe you're just taking a quiet afternoon walk.
Right. Very normal stuff.
Exactly. And suddenly, a police officer steps directly in front of you. They hold up a hand, look you right in the eye, and demand your name.
Oh, wow. Yeah.
It's a high-stakes, incredibly tense scenario, right?
Yeah.
Most of us instantly recognize it from movies, the evening news, or maybe even personal experience. Your heart starts racing and your mind flashes to this universally relatable question, do you legally have to answer?
Well, it feels like the answer should be a simple yes or no. You kind of expect the law to be binary here. Like either an officer has the authority to demand your identity on a public sidewalk, or they absolutely don't.
Right. You'd think it's one or the other.
Yeah, but the reality of an interaction on the street is anything but clean. It is, frankly, incredibly murky and filled with these invisible legal tripwires.
Which is exactly why we are doing this deep dive today. We've pulled together a massive stack of legal documentation, case histories, and legislative summaries for this deep dive.
A lot of dense reading.
Oh yeah, tons of it. Our mission today is to decode the exact legal boundaries of police interactions. We are going to cut through the common myths, the impenetrable legal jargon, and the exaggerated courtroom drama.
Because there's a lot of that.
So much of it. We really want to help you understand your actual rights and the incredibly complex legal reality of identifying yourself in the United States.
What's fascinating here is that this entire topic is essentially a massive ongoing philosophical tug of war.
Okay, how so?
Well, on one side of the rope, you have the very real, practical need for public safety, right? The ability of law enforcement to investigate crimes effectively.
Sure, that makes sense.
But then on the other side of the rope, you have the Fourth Amendment of the U.S. Constitution, and that explicitly protects you against unreasonable searches and seizures.
Right.
So every single law and court case we are about to discuss lives right in the middle of that friction.
Okay, let's unpack this. Because before we can even talk about whether you have to give your name like these specific stop and identify laws, we really need to build a firm baseline.
Yeah, that's crucial.
We have to understand when these laws actually trigger in the real world, because they do not apply to every single interaction you have with a cop. Reading through the sources, it's almost like a video game with 3 escalating threat levels.
I like that analogy. The law categorizes your interactions with law enforcement into 3 distinct escalating tiers. And your rights change dramatically depending on which tier you are currently occupying.
Right. So let's start at level 1, which the legal system calls a consensual encounter. This is the absolute lowest level. The police can walk up to anyone at any time in a public space and just start asking questions.
Exactly. They might suspect something is up, or they might just be canvassing the neighborhood. But they don't have any concrete proof of a crime yet?
So in this tier, you are not required to identify yourself. You don't have to answer a single question, and theoretically, you can just walk away.
Theoretically, yes.
But, here's where I have to push back on the legal terminology a bit. If a police officer in full uniform, wearing a badge, a radio, and a firearm, walks up to me on a quiet street, it never feels consensual.
No, of course not.
It feels like an order. How is a regular person supposed to know the difference in the heat of the moment?
That is the exact trap of the first tier, and the courts are fully aware of it. The Supreme Court has explicitly stated that police are not required to tell you that you're free to decline their questions.
Wait, really? They don't have to tell you?
Nope. They don't have to announce that you can just go about your business. The burden is entirely on your shoulders to figure out if you're in a consensual encounter or something way more serious.
That is wild.
And really, the only reliable way you determine that is by asking one very specific, direct question.
Which is,
am I free to go? If the officer says yes, or simply steps aside and doesn't stop you from leaving, you are squarely in Tier 1.
Okay, but if they say no, or they physically block your path, suddenly you just leveled up to level 2.
Yeah. When that happens, you've crossed the line into Tier 2, which is reasonable suspicion. This is officially a detention.
Okay.
You are legally detained when the circumstances are such that a reasonable person would believe they are not free to leave the area.
And this isn't just a gut feeling or like a hunch on the officer's part, right?
No, definitely not.
The sources emphasize that to legally detain you at this second level, the officer needs specific and articulable facts.
Yes, that phrase is key. Specific and articulable facts.
So they can't just vaguely claim you look suspicious or we're walking in a bad neighborhood. They have to be able to articulate that a crime is being or is about to be committed, right? Based on observable reality.
Exactly. An articulable fact isn't just, he looked sketchy. It's more like he matches the exact physical description of a suspect from a robbery that happened 2 blocks away 5 minutes ago. And he has a visible bulge in his waistband that looks like a weapon.
Ah, okay. That's very specific.
Right. That is the specific hook they need to freeze the situation. But here is the critical detail. While the officer must possess that reasonable suspicion in their own mind, they have absolutely no obligation to tell you what that suspicion is right there on the street.
You're kidding. So you're just stuck there not knowing why.
Pretty much. The only time they are forced to formally articulate those facts is later in a courtroom if you decide to challenge the legality of the stop.
Wow. Okay. Which brings us to level 3 arrest. This is the highest tier. To put you in handcuffs and actually arrest you, the officer needs to meet a much higher legal standard than reasonable suspicion.
Yes, a big jump up.
They need probable cause to believe you actually committed a specific crime. Now, I think a lot of people instantly think of the Miranda warning here. You have the right to remain silent. Anything you say can and will be used against you.
Right, the classic TV cop show line.
Exactly. But looking at the case files, there is a massive, fascinating exception here. Miranda does not apply to the basic biographical data needed to complete the booking process at the police station.
Yeah, that trips a lot of people up. Once you are fully arrested and going through booking, the rules change entirely. The police are allowed to ask your name, your date of birth, and your address without reading you your Miranda rights.
Because it's just paperwork.
Essentially, yes, because those are considered administrative questions, not an interrogation about the crime itself. But the real friction, the absolute battleground for these stop and identify laws we're exploring, it doesn't happen at Tier 1, and it doesn't happen at Tier 3.
Right. It lives entirely in Tier 2, the detention phase.
Exactly. Because if you're free to go, you don't have to talk at all. And if you're arrested, well, you're already going to jail regardless of what you say.
Yeah, that ship has sailed.
It's that messy middle space when you are detained but not yet arrested that causes all the constitutional confusion.
And to really understand that middle space, we have to look back at a landmark Supreme Court case from 1968 called Terry v. Ohio. This is the case that essentially created Tier 2.
A hugely important case.
Yeah, so a detective in Cleveland saw 2 men pacing back and forth in front of a store, looking in the window. And he suspected they were casing the joint for a robbery. The Supreme Court eventually ruled that police can temporarily detain someone and frisk their outer clothing for weapons if they have reasonable suspicion.
Right.
And that's why detention is so often called a Terry stop.
Exactly. The Terry stop gave police this unprecedented power to freeze a situation on the sidewalk and check for weapons to ensure their own physical safety while they investigate a potential crime.
Makes sense for safety.
It does. But for decades after that 1968 ruling, a massive, glaring legal question remained completely unresolved. During this temporary freeze, this Terry stop, could you be arrested for simply refusing to open your mouth and tell the officer your name?
And federal circuit courts were totally split on this across the country. Even the Supreme Court dodged the question twice in the 80s and 90s.
They really didn't want to touch it.
But here's where it gets really interesting. Think of a Terry stop like a fishing analogy. The police can't just throw out a massive net and indiscriminately fish for personal information from anyone walking by the park.
Right, they can't just trawl.
They need a specific hook.
Right.
Those articulable facts we talked about, before they can even cast the line to demand your name.
And the Supreme Court finally had to decide what happens when an officer actually uses that hook and the citizen refuses to bite.
And that happened in 2004, right?
Yeah, in a case called Hiibel v. 6th Judicial District Court of Nevada. In this case, police responded to a report of an assault. They found a man named Dudley Hiibel parked on the side of the road, and he matched the description. Okay. The officer asked for his identification. Hiibel, believing he had the right to remain silent, absolutely refused. In fact, the transcript shows he refused to identify himself 11 different times during the interaction.
11 times.
Yeah, he was practically taunting the officer to just arrest him. So the officer did. He was convicted under Nevada state law for his refusal.
And he took it all the way up to the Supreme Court, arguing that forcing him to give his name violated his Fourth Amendment right against unreasonable searches and his Fifth Amendment right against self-incrimination.
Right.
But he lost. The Supreme Court ruled that requiring suspects to disclose their names during a valid Terry stop does not violate the Constitution. Unless, in some extremely rare hypothetical circumstance, the name itself would be uniquely incriminating to a completely separate crime.
The court reasoned that knowing who they are dealing with is a fundamental part of an officer's ability to safely and effectively conduct a Terry stop.
Right, they need to know who's in front of them.
Exactly. If they are investigating a reported domestic violence incident, they need to know if the person standing there has a history of extreme violence or, outstanding warrants. The state's interest in officer safety outweighed the minimal intrusion of just stating a name.
But wait, did Hiibel have to physically hand over an ID card or just say his name out loud? Because practically speaking, on the street, that feels like a massive distinction.
It is a huge distinction, and the court was incredibly clear in its interpretation of the Nevada law at issue. They explicitly stated that the law did not require a suspect to hand over a driver's license or a piece of plastic.
Oh, really?
Yeah, merely stating his name or communicating it by other means, like writing it down, would have entirely satisfied the statute. The legal obligation the court upheld was strictly about verbal identification.
So the Hiibel case gives states the constitutional green light. It essentially says, yes, states, if you want to pass laws requiring people to identify themselves during a Terry stop, you have our permission.
They opened the door?
And following that 2004 ruling, we transition into how individual states actually implemented this power. Because looking at our research, it is absolutely not a unified national rule.
Not at all.
It is a chaotic, confusing patchwork of state legislation.
This is where the abstract constitutional theory directly impacts you, the listener, depending entirely on where you live or where you might be taking a road trip. Currently, 24 states have some version of a stop and identify statute on the books.
That's about half.
Right. But the specific wording, the triggers, and the consequences vary wildly from state to state.
Let's look at some examples to show just how messy this gets.
Yeah.
In some states, like Arizona, the law specifically requires you to provide your true full name. Indiana is even more demanding. If you are stopped for a basic infraction, you have to provide either your name, address, and date of birth, or hand over a driver's license if you have one on you.
But then moving to states like Illinois or New Hampshire reveals a totally different approach. Their statutes literally say police may demand identifying information from a suspect.
May demand. That sounds pretty forceful.
It does. But however, the state courts there have ruled that the word demand just authorizes the officer to ask the question. It doesn't actually impose a binding legal requirement on the citizen to answer.
Wow, so it's a demand you can just ignore.
Basically, in Illinois, refusing to provide your name during a Terry stop is essentially considered a form of argument with the police, which is protected by the First Amendment. You cannot be arrested just for keeping your mouth shut.
That is crazy. Imagine living on the border of Indiana and Illinois. You cross an invisible line in your morning jog. You get stopped because you match the description of a burglar, and suddenly your constitutional obligations completely flip.
It really is madness.
So what does this all mean? It is incredibly confusing for an average citizen trying to follow the law. And to make matters worse, some states use what our sources reveal to be an obstruction backdoor.
Oh, this is a big one.
Let me use an analogy here. Imagine a parent telling a teenager, I demand you clean your room. But the parent has set no actual punishment for having a dirty room. So the teenager says no. The parent can't punish them for the room itself. So instead, they ground the kid for the disrespect of saying no. It's infuriating. It's the legal equivalent of, because I said so. You're essentially being arrested for bruising the officer's ego, disguised as a statute.
The obstruction loophole functions legally in exactly that way. In states like Nevada and Utah, the actual stop and identify statute doesn't have a specific criminal penalty written into its text.
So it's a rule with no teeth.
Exactly. If you break that specific rule, there's no fine or jail time attached. However, police use a completely separate, broader law against obstructing a peace officer.
Oh, I see.
We see this perfectly illustrated in a case called Oliver v. Woods out of Utah. The court concluded that even though the stop and ID law didn't have its own penalty, failing to follow a lawful order from an officer actively investigating a crime constitutes obstruction.
Wow, so they get you through the back door.
Precisely. You aren't charged with failing to identify, you are charged with interfering with an active investigation.
That is wild. The legal gymnastics required to navigate that on a sidewalk while your adrenaline is pumping is asking a lot of an average person.
It really is.
And this brings us to what might be the single biggest misunderstanding we found in this entire deep dive. We need to tackle the myth of the physical ID card.
There is a massive, widespread misconception here among both the general public and, frankly, many patrol officers about what identification actually means outside the context of a vehicle.
Right, because if you were driving a car on public roads, you have agreed to a very specific set of administrative rules. The vehicle codes in every single state require you to produce a physical driver's license if you are pulled over.
Yes, that is totally settled law.
But if you're walking your dog or just sitting on a park bench and a Terry stop occurs...
What then?
Wait, looking at these case files, California actually tried to pass a law requiring credible and reliable ID, but the Supreme Court struck it down in 1983 in a case called Colander v. Lawson.
They did.
They struck it down because it basically let cops play an arbitrary guessing game on what counts as ID, a passport for you, a gym card for me, a utility bill for someone else.
Right. The Supreme Court struck it down based on the void for vagueness doctrine. The court realized that leaving it up to an individual officer on the street to decide what counts as credible and reliable gives the police way too much arbitrary discretion.
Which leads to problems.
Huge problems. It invites discriminatory enforcement. So unless you are operating a motor vehicle, there is absolutely no federal requirement to provide written or physical identification during a Terry stop. As we saw with the Hiibel case, your obligation is verbal.
And then there's the issue of how far police can physically go to look for that ID. There's a fascinating California case from 2006, People v. Garcia. An officer detained a man, patted him down, felt a lump, and pulled out his wallet to find his ID.
And the court stepped in and said, absolutely not.
Wow. So they can't even look for it.
The Garcia court issued a very strong ruling reminding everyone of the original narrow purpose of the Terry stop. The Terry frisk was created solely for officer safety.
Right, looking for weapons.
Exactly. An officer can only pat down your outer clothing to ensure you don't have a gun or a knife. They cannot conduct a pat-down search just to dig into your pockets for your wallet or hunt for an ID card. A wallet is not a weapon. If they feel a soft, square object in your pocket, they cannot legally reach in and grab it.
Wait, so if I'm not driving, I can just leave my wallet at home. I can just walk around with absolutely no physical proof of who I am.
Yep, you absolutely can.
But what happens if they actually arrest me? Surely the rules change when you get to the station.
They do. If you are not driving, you are generally under no legal obligation to carry a physical ID card in the United States. You can leave your wallet on your kitchen counter.
Okay.
However, if you are placed under lawful arrest for a crime, meaning we have moved to Tier 3, probable cause, and you refuse to verbally give your name or you give a fake name, things will go very badly for you.
I can imagine.
While you might not be legally required to have a plastic card in your pocket, refusing to tell them who you are at the booking station will essentially guarantee that you sit in a jail cell as a John Doe.
Oh, man.
Yeah, they cannot process you, they cannot set bail, and you will not be getting released until they can fingerprint you and figure out exactly who they are holding.
That makes perfect sense. The justice system inherently needs to know who it's processing. But to really grasp how unique this American system is, we need to zoom out a bit.
It's good to get some perspective.
Yeah, we need to transition from looking at state borders to looking at international borders. How does the U.S. constitutional approach to all of this compare to the rest of the world?
It's a stark contrast,
Yeah.
deeply rooted in different philosophies of state power. Many countries around the world, particularly civil law nations, mandate that citizens carry national identity cards at all times.
Really, at all times.
Well, yes. Let's look at Portugal, for example. In Portugal, it is compulsory by law to carry your cartão de cidadão, your citizen card. It's an electronic card packed with biometric data, your fiscal information, your social security number, everything.
Oh, no.
And if the police have reasonable suspicion and you don't have that card on you, or at least a certified copy of it, they won't just ask your name and let it go.
What do?
They have the legal authority to physically escort you to the police department and detain you there until your identity can be definitively scientifically proven.
Wow. That is a fundamentally different philosophy on privacy. It treats the citizen as someone who constantly needs to prove they belong.
It really does.
But then you look at countries that share our English common law roots, and it swings the completely other way. In the UK, Canada, Australia, and New Zealand, police generally have no broad sweeping power to demand your identification on the street without a very specific statutory reason.
Right. In the UK, for instance, a pedestrian walking down the street doesn't have to provide any details unless they are actively being placed under arrest.
None at all.
Well, there is a specific exception, Section 50 of the Police Reform Act, which allows an officer to demand a name and address, but only if they believe the person has been engaging in antisocial behavior or is committing a public order offense.
Okay, so a very specific trigger.
Yes, it's a very narrow, specific power designed to handle street harassment, not a general tool for every single police interaction. Outside of those narrow exceptions, the police cannot force you to identify yourself.
Looking at it globally, the United States really sits in this messy middle. We aren't a strict show your papers society like Portugal.
Definitely not.
The idea of being forced to carry a national ID card goes against a lot of American cultural DNA.
Yeah,
We have a deep historical distrust of centralized tracking.
for sure.
But at the same time, because of our federal system, we don't have a clean, unified standard like the UK. We have a complicated, highly localized web of legal traps where your fundamental rights literally change the second you cross a state line.
If we connect this to the bigger picture, the takeaways from this deep dive are entirely about situational awareness.
Right. What should people remember?
If you find yourself interacting with law enforcement, your best tool is a polite but firm script. First, establish the tier of the encounter by asking, "Officer, am I being detained or am I free to go?"
Get it on the record.
Exactly. If they say you are detained, follow up with, "What specific crime do you suspect me of committing?" It forces the interaction out of the murky gray area and into the light. Understand that your state laws dictate your obligation to speak. And finally, recognize the critical legal difference between verbally stating your name and being compelled to produce a physical card from your pocket.
The law, as it currently stands, is built entirely around that exact physical interaction. The friction of verbally stating a name, the physical act of reaching into a pocket for a piece of plastic.
Yeah, very physical concepts.
But I want to leave you with a final thought today. Something to really chew on that builds on all these sources, but points to where this is inevitably heading. Think about the relentless march of technology.
Oh, yeah.
What happens in a few years when patrol officers are wearing augmented reality glasses equipped with real-time, highly accurate facial recognition?
That changes the whole game.
If the state instantly knows who you are, your home address, and your entire criminal record, the very second they look at you on the sidewalk, does the entire constitutional concept of a stop and identify statute become completely obsolete?
It's a great question.
How does the delicate legal balance of a Terry stop change when anonymity in public is mathematically impossible? It's something to think about the next time you're walking down the street minding your own business and someone steps in front of you.